Thank you very much. And thank you to the whole organizing committee for the opportunity to be here. I might make some links to administrative law. Certainly some of the topics will touch upon topics that were just discussed and will be discussed tomorrow as well. But really, I think this presentation is quite different from the two other ones in this session, because this is really about the states. This is here. It is the state that is the active party, and in relation to other states. Port state jurisdiction is about public international law, mostly, but not only law of the sea. And so this is going to be back to where we started, in fact, to UNCLOS and this type of matters. It doesn't start well. I realize that one of my affiliation is not on the screen there, but in the program it is correct, and how you introduced me was correct. The Tromsø affiliation is missing there, unfortunately, but that's a mistake from my side. Yes. So why do I talk about port state jurisdiction? Well, apart from the obvious fact that I was invited to talk about port state jurisdiction, but I think it's one of the most fascinating fields to study if one is interested in the dynamics of shipping regulation, basically at international level. This is where all the action is, I would dare to say, even in the field of port state jurisdiction. Because to make it a caricature, it a bit basically regulating flag state has the drawback, and you will never get a complete coverage in that way. And the Law of the Sea Convention basically put the lid on what coastal states can do, that is for ships only passing along with your coast, but left the question of port state jurisdiction. How far can port state regulate foreign ships that come to your ports? Left that question almost completely open, which has in its wake resulted in quite interesting development. Not all of this is dependent on the Law of the Sea Convention. Some of the port state jurisdiction exercises are quite old, 100 years old and so forth, the well-known examples. But I think there has been a marked acceleration of the use of this type of rules in the past 2 or so decades, and that's the period I intend to cover here. Basically, what I try to do is to, following a general introduction of the concept as such, I will just illustrate by means of some examples what has happened in practice, how port state jurisdiction has been used, and in what format and what context, even noting a little bit of potential future challenges to its use. But then the second, towards the end of the presentation, I will then discuss the legal limitations of this, because it is really about, there is some uncertainty about how far states actually can exercise port state jurisdiction. And I think that is, well, that covers it. Then there will be some conclusions, obviously, towards the end. So I think one needs to separate a little bit, because quite often it's mixed up, the concept of port state control, which we just heard about, and port state jurisdiction. I think port state control in my world is a very sort of technical task of exercising control of international rules on ships that come to the ports. So it's not really about challenging the international rules in any way, or or inventing new rules. It's about making sure that they work, because the flag states are not trusted. Port states come in as a second line of defense to check the same thing as the flag states ought to have been doing. That is port state control. Port state jurisdiction is going further than that. That is making jurisdictional use of the presence of the ship in the port to actually impose rules on it. That's the prescriptive part of port state jurisdiction. As you know, UNCLOS has separate rules for prescriptive jurisdiction, what laws can a state make, and enforcement. How will those rules be implemented in practice? And so I'll start immediately with the review of general development, because it's quite broad, and I might not even be able to cover it all. It's quite, also from an academic point of view, it's quite a good time to speak about this now, because we have recently had 2 very solid PhD theses written and published at the University of Utrecht in the Netherlands about port state jurisdiction. One dealing specifically with fisheries, and the other one more with commercial shipping and in particular environmental requirements. But this development takes place in other areas too. I will cover maritime safety and environmental rules, both internationally and at EU, then fisheries, maybe say a word or two of international private law, and there are some other examples as well coming up now, for instance, using port state jurisdiction as a basis for requiring salary and social conditions for crew working on ships that are closely linked to the port in question and so forth. So it goes beyond these topics. And the focus of my review is international rules and EU rules. I don't go into national examples here. Starting with the IMO conventions, I mean, from this point of view, you can maybe divide them into 2 different categories. You have the old style IMO conventions, which didn't mention this at all. They were developed for flag state and put down the minimum requirements for flag states, and a little bit of port state control on that. And that was it basically. But they also included a very interesting provision, which was called the no more favorable treatment clause. Almost all IMO conventions include that. And that clause says that you should treat parties to the convention, ships flying the flag of a party to the convention, in the same way as non-parties. And of course you couldn't do that under treaty law, because you cannot in one treaty create obligations for non-parties. But the reason why you still can do it is because of port state jurisdiction. There is a possibility for port states to exercise the jurisdiction because the ship is voluntarily there in their port. And through that, even if it hasn't been made so explicit, this system has been working for decades and has been well accepted. More recent conventions in IMO, in fact, specifically deal with this question, and usually in the form that they say that in this convention we don't, this convention does not preclude the right of port states to go beyond and to actually impose further regulations. We have some examples of those sort of rules. So they have started to acknowledge the sort of residual jurisdiction that port states have, in addition to the rules that have been agreed in the conventions. But for the IMO conventions, of course, a critical question remains that is this IMO convention, if states agree in an IMO convention about a certain rule, for instance, that ships should have double hulls, can port states then, through exercising port state jurisdiction agree on something else, that they should have triple hull when they come to your ports. I mean, this is of course not a real example, but it raises the question whether the convention represents a kind of package deal or whether it is just a minimum requirement which state may depart from as port states if they want. And that question is not very easy to answer, and I think that there are many elements to it that I will come back to some of them. But generally, the biggest purpose of port state jurisdiction is the biggest consumer of port state jurisdiction is not the IMO, because they can make their rules if they need that. They can use the flag state and cover the whole world through that. The biggest consumer of port state jurisdiction are states that are unhappy with the existing rules, whether it's IMO rules or some other rules, and want to do something more, different, better. And they, of course, don't want to do it for their own flags only, because that would put them in a disadvantageous situation. And they cannot do it in most cases for passing ships, but through port state jurisdiction they have this possibility. And in fact, this is the basis of the European Union's entire maritime safety policy, is basically to implement rules for any ship, irrespective of nationality, that come to EU ports. Some 30 out of 40 directives have this element. They are basically regulating all ships in this way. And there, of course, lies the big benefit in being a large area doing it jointly, that you avoid the risk that by implementing rules very strictly, the ships, if you are a small state like Belgium, would do it alone. It would only mean that ships would prefer to go to Holland instead. But if you are 27 states acting together, that risk is very much diminished. Well, still, most of the EU rules are very closely linked to international IMO rules, but I'll try to show in two pictures that follow that in the most active period of EU legislation, it was 12 years, there has been increasing independence, both in terms of what rules are required, but also how they are enforced. I have indicated there on the vertical axis 4 different stages. One is just implementing international rules, like the Port State Control Directive does. Then the next step is making non-binding international rules binding for ships coming to EU waters. That is going a bit further. But still further is to complement the international rules by additional rules, well, like the Port Waste Reception Facilities Directive, where the international rules are quite vague, and EU rules specify a lot of things in addition. And then the last one is competing with the international rules, where international rules says something and EU rules says something different. The final step there is violation of the international rules, but I haven't dared to put it there. But you can see that there is a trend in development here. These are the port state directives that are most easy to place, and in this period, clearly there is a tendency to be more and more independent of the international rules. In fact, the EU has even done an interesting thing. They have created a completely new concept, which is called the host state concept, which goes even further. And that is nothing to do with law of the sea. It comes from the EU law on provision of services, basically. And they have implemented for passenger ships in particular, that in order for a passenger ship to provide a service, it needs to fulfill certain, between or to or from one EU port, it needs to fulfill a number of additional criteria. But the same thing on the enforcement side. If you just think that if somebody violates the rules, what is the consequence? First, you can have just control. That was originally the method to do it. Then you could start doing various conditions for when the ship can leave. You can even start detaining it. That came with the Port State Control Directive. You can start banning it from all European ports in certain conditions. And then you have the passenger ship services. But then you can also refuse access to the port altogether, which is even more dramatic. And you can have that for an individual port or for all EU port. And finally, you can have criminal sanctions against. And here again, quite a clear development and the reason why the development stops there is that there were some more directives adopted in 2009 in particular, but since then they were not particularly challenging from this point of view, and since then there hasn't been very much legislative activity in the EU. There is one instrument in particular which is interesting, and that has to do with climate change, the so-called MRV regulation about monitoring and reporting and verifying ships' emissions for ships coming to EU port. It is clearly up there relatively high on both of these scales, because it says that if a ship does not comply with these reporting requirements, it will eventually be banned from all EU ports. And that was adopted in 2015, before the corresponding IMO rules were adopted. So that was the EU. In fisheries, there has been a somewhat similar development. I think what was most interesting with the fish stocks agreement that was adopted in 1995 was that it recognized this port state jurisdiction as a right, but also as a duty for states. That port states had a duty to make sure that fishing vessels of all flags actually complied with the required standards. And what exactly this means were then set out in certain voluntary standards, first in 2001 and then in 2005. But finally, in 2009, there was the Port State Measures Agreement agreed within the Food and Agriculture Organization, and that entered into force in 2016. And that provides for some details on how port states shall make sure that their duties and rights are implemented. Basically, a starting point has been that ships that are engaged in IUU fishing should not be allowed. This is at least the European interpretation of this rule, that they should not be allowed to enter ports, in EU ports, or land their catches in EU ports if they do not comply with the fisheries standards. Other states have subsequently been going further with different types of sanctions for non-complying fishing vessels that want to come to ports. There is an interesting thing also with the European measure on port states, because it also, through its sanctions as a port state, it sanctions states who do not fulfill their port state obligations. So it's not only when states do not meet their obligations as fishing flag states that they are sanctioned, but also when they don't meet the port state obligation, even for non-parties to the agreements, the Port Sea Measures Agreement, which is quite interesting. And it kind of sort of double acts on the port state jurisdiction. I'm stressing a bit here because I want to discuss the legal issues thoroughly. Well, let's not go into this now. It's basically just to indicate that in this area too, when it comes to employment contracts in European regulation, it is far from clear as it once was that it's usually the flag state that governs, that is the applicable law for employment contracts if a particular choice of law has not been made in the contract itself. More and more it comes down to other types of criteria, and these are increasingly being used also by courts in practice. Then we have another category of port state jurisdiction developments, which is different. First, there are certain of the United Nations Security Council resolutions that oblige all states to actually take various types of port state measures against ships that do not meet various sanction requirements with respect to North Korea and Yemen. In particular, North Korea, there is a whole range of these, the latest ones being from 2017, and Yemen is from 2015. It goes further also, it requires it to inspect and actually seize the cargo of ships that are found to be violating the sanctions. But from a jurisdiction point of view, these are not particularly problematic, I think, because this is United Nations Charter, Chapter 7, Security Council adopts, and basically this wins over any general considerations of law of the sea or port state jurisdiction. But some examples exist also relating to this type of political sanctions without such backing in Security Council. There are probably other examples as well, but one quite interesting is when several Persian Gulf countries decided to start sanctioning Qatar for its activities as they claimed in supporting terrorism and not doing what it could to, representing a security threat in the region. Among the sanctions to be implemented were all sorts of port state, quite drastic port state measures. Ships that were from Qatar were banned from the ports of the countries, but also ships coming from a port in Qatar or going to a port in Qatar, and in some cases even relating to the cargo carried. And this is, of course, a very different thing if you don't have a Security Council resolution backing in justifying this type of very far-reaching goals for security reasons against a particular state on the basis of port state jurisdiction. That your ship comes here, it doesn't have a right to be here, so we can do it. I wanted to spend 1 minute also to look a little bit ahead, because now these previous slides have been sort of a very brief review of what has happened in various areas in the recent past. But I think that there are several reasons to believe that port state jurisdiction has not reached its peak at all. In fact, it's probably going to be even more attractive for states to be used as a tool for regulating maritime traffic in the future. And the main reason for that, I think, is simply technology. It is so much easier now than it ever used to be to have control of where ships are, how they are trading and what they are doing. Because that, of course, was a big problem some decades ago only, that a ship was in port, but how on earth could you know for sure where it had been and what it had been doing? Now, through various types of databases and satellite systems and all sorts of monitoring tools, it's quite easy to check out what ships have been doing and then enforce it when it comes to port. In particular on the high seas, where there has been a big problem in the past, where nobody really has had jurisdiction. So there is a kind of a push towards regulating what happens on the high seas, or enforcing it also in this way. For example, we talked about navigation in the Arctic. If you would want to have some particular rules for ships traveling in the Arctic, for instance, the European Union, it doesn't have a coastal area in that region, but most of the ships that are in through traffic in the northern sea route would have a European port as a start or end port. So I mean, that could be an example of how port state jurisdiction could be used in this extraterritorial manner in the future. The most hyped regulatory discussion for the moment is, of course, the marine autonomous surface ships, the automated ships or remotely controlled ships. It raises some questions of Law of the Sea Convention, but as opposed to some lawyers, I don't think the Law of the Sea Convention in any way prevents this development, but it does require that IMO is on board, that it sort of endorses it. But there are some interesting consequences. What do you do with when you have jurisdiction over the ship, if we talk about remotely operated ship, but you don't have jurisdiction over the people who drive the ship? I mean, because they might be sitting in a different world altogether, and this might give rise to completely new type of enforcement measures needed also. So, but again, I think port state jurisdiction, both as a regulating tool and as an enforcement tool, will be very critical in developing any new mechanisms to cater for also this development. So then, all this happens and is likely to continue happening, but what are the limits? What are the responsibilities of the port state? But where does the law come against this and say, this goes too far? There is not really a very good answer to this, or a simple answer to this question, unfortunately. Probably the easiest answer relates to enforcement, what measures states can take with respect to ships that are in their port, because we have a lot of very important rules in the Law of the Sea Convention, which are generally accepted, the safeguards in Part 12, and the tribunal has also in the Virginia case stated that even if this is part of the Part 12 of the convention, basically these safeguards apply to other enforcement measures as well. And we have also examples of various types of restraints and limitations on port states in exercising enforcement. But we don't have any case law really at the international level about the prescription side. How many requirements can a port state place? Not even at national level are there judgments on this. I know of only two, and they go in the opposite direction. One is Swedish and one is from New Zealand, and they say completely different things. But I think at least that this development that I just outlined on the very significant development of how this jurisdiction has been used in practice has had an effect also on customary law since UNCLOS was adopted. And let's look at the question now. I think I have 5 more minutes. Don't you? First, the starting point when starting to analyze this question is of course that ports are located in the internal waters. It's part of the territorial sovereignty of the states, and there is no access for ships to go to foreign ports. There is no right to access ports under international law. And of course, if there is no right to access port, that implies that there is also a right for the port state to place conditions on the access. But as I mentioned, UNCLOS is very unspecific on this matter. It hardly deals with it at all. Just some indications in those 2 articles or paragraphs I mentioned there. And the IMO conventions before a certain date did not really deal with this aspect either, as I also mentioned. So they don't really help very much in putting those limits. I mean, the IMO conventions are drafted always as minimum standards for the flag states. But whether they are also maximum standards for the port state, they don't say. And arguably, they should say it if they are supposed to represent such kind of infringement or intrusion to the jurisdiction of the port states. But there may be other types of international law, of course, that puts limitation. There is quite a lot of bilateral agreements between states about providing access and equal treatment and all this. And then, of course, we have the whole WTO body of laws, which may be implicated in this sort, because it's also based on non-discrimination and national treatment and this sort of thing. So if you start singling out certain types of ships or certain nationalities in particular, you will very quickly have problems also in that field. And there are some interesting cases in the dispute settlement body of the WTO which can be used as a parallel for this unilateralism / multilateralism discussion that we have here. But some requirements apply irrespectively. You cannot discriminate, really. This is, I suppose, the biggest problem with the Qatar, that you cannot single out under the law of the sea, at least a single nation and discriminate against that. There is also a prohibition of use of right, and there are different types of international legal requirement on proportionality and reasonableness. So these would apply in any case. But then, if there are no other treaties that apply to the question, we are still faced with this main issue on what can a port state do. And basically, you had 2 approaches here under the law of the sea convention. One says that, well, you need a prescriptive basis to do it, which means that you cannot do it for areas beyond your exclusive economic zone, at least for requirements there. But the other one says that, well, you don't have to come here if you don't like our rules, but if you come here, we impose our rules, and it's a bit more subtle than that. But that is basically the 2 approaches that you can find as a starting point. I think it is also important to bear in mind that the relevance of the argument depends on what type of rules we are talking about. Are they static? Are they the same rules, like the double hull requirement for a tanker? If a port state says that we don't only want double hull requirement tankers in our port, it means, of course, that the ship will have to be double hull tanker all the time, because you cannot change. But on the other hand, it's easier to argue for that sort of rules, because then you can say that, well, the port state said that we are only regulating our port. It's just a coincidence that it happens to apply everywhere else, but you are violating the rule here. With discharges, it's more tricky, but there you have a specific UNCLOS provision which gives extraterritorial jurisdiction. And the biggest legal problem, I think, is when it comes to rules that are not discharges, but not construction rules either. They are operational rules relating to how ships behave away from the port state's own jurisdiction. You can also say that this is not really about the law of the sea at all. You don't have to resolve it within that context, because the law of the sea convention itself says that there is whatever is not regulated here is regulated by general international law, and that has other types of rules for extraterritorial jurisdiction that could be relevant here. And it also is relevant what type of measures the port state takes to violate, to sanction against the ship that violates the rules. Because if you are only saying no to access to ports, for example, or access to services to which the ship has no right, it's easier than to issue a fine, for example, because then you would have to motivate it much more clearly why you have the jurisdiction of the extraterritorial jurisdiction. And these are not necessarily, I mean, the most stringent enforcement measures, like banning a ship from all ports in the region, they are easier to justify than a simple fine, even if a simple fine would probably be much more preferred by a ship. So you can arrive at the result of this question from various points of view. You can arrive it from the law of the sea, you can arrive it from general international law or international trade law, but in the end the principles will be very similar, and that is the outcome of my research in this field, that it's in the end it boils down to the same type of balancing of interest between the port state and the international interests. So my concluding slide says that legality ultimately depends on the nature of the obligation, on the chosen methods to enforce it, and on the general reasonableness, etc. But also more academics start to emphasize the objective of the measure. Is it for the common good? It might be easier to justify than if it's for purely national interests. I shall not speak very much about this, but this is my last slide. I just highlight it because this is a list of potential interests that need to be taken into account when this assessment is made by a court in assessing, in my view, under any of these principles, if the port state actually overstepped the border of legality when it introduced these measures. The only point I would like to make, and that's my final one, is the last point there. Because I think it's obvious that any type of balancing between these questions will depend on whether you bring the case to the International Tribunal for the Law of the Sea, or the International Court of Justice, or the European Court of Justice, or the WTO dispute settlement body. So you really have a case of forum shopping when it comes to port state jurisdiction, which is interesting in itself. I'll stop here. Thank you very much.